Hi, Neil.
Hi, good afternoon, everybody. We're going to get started in just a moment. We'll let those of you who registered log on. I will get our PowerPoint presentation up and ready, and we'll be right with you.
You got the PowerPoint?
Yeah, just a minute.
And if anyone has questions during the presentation, you can try to do the chat or email us directly afterwards. We can even share the PowerPoint with you guys too.
Okay, so you should be seeing it now.
I see it.
All right, good. Well, thank you for joining us this afternoon. We're glad to have you with us. I'm Neil Kalin. You see there is also sharing the screen with me is Michael Simkin. And we've got some interesting cases to discuss with you today. And hopefully we have a really interesting person that Michael is going to interview, a recently retired judge, Judge Kalin. And so if he's able to get away from his busy schedule, we're going to interrupt whatever we are doing at the time to take him, right, Michael?
That's right. He's in the middle of a mediation, so we'll see what happens. If
Okay.
not, we'll just talk about something interesting.
Right. There we go. There we go. Always we do that. Okay. So here we go. What's our agenda today? First, I was gone last month, and we'll see. I think Michael is kind of a little bit glad that I'm back. And we've got our four cases: coastal protection versus Airbnb, and we've got Iton versus County of Los Angeles, Carr versus City of Newport Beach, and Alliance San Diego versus, I believe it's the City of San Diego. And then we'll talk about a few upcoming events and how you can get involved with the real property section if you are interested in doing that. And we hope you are. So Michael learned last month, he thought, oh, I like doing these What's Up with Us every month. It's easy. I show up, I talk about the cases, maybe I read through or scan through the cases in advance, and then all of a sudden he had to do all of the work. He had to find the cases, read the cases, summarize the cases, prepare the PowerPoint, make sure everything was set up with our staff people, and get us started. So Michael, it's a lot easier load if somebody is helping you out. And I'm glad you're here to help me out with these things. So good to be back. Good to be back. So let's see, what do we got going? Michael, you want to start talking about Coastal Protection Alliance versus Airbnb? And there's been a lot of cases over the last few years involving either Airbnb or short-term rentals generally. A lot of them having to do with attempts to prohibit short-term rentals, whether by a homeowner association or by a city or a locality. But this case really has a little different flavor to it. So tell us about this case and we can discuss it.
Well, the Coastal Protection Alliance and let's focus on the word alliance versus Airbnb, some people took a different approach. They were trying to find a way to attack short-term rentals that would be statewide. And so they formed a little coalition, Coastal Protection Alliance, Inc., a nonprofit, which I think is based out of San Bernardino. So I always wondered which coast is adjacent to San Bernardino, but that's another issue, right? But they brought an action to challenge basically every short-term rental that exists, say, along the coast. And one of the things I've noticed in court is when someone's, you bite off more than you can chew. You can't do that. This is a case also involved with demur. Most demurs, even if they're sustained, they get, overruled at some point. But this one was interesting, and I'll tell you what was interesting about it. So this Alliance for Protection, Coastal Protection Alliance, their challenge is focusing on a phrase inside the Coastal Act. And the court was trying to apply some common sense interpretation to the word development. So what happened is inside section 30106, there's a phrase where it describes what types of properties are defined as a development. And part of the phrase included where it said, any change in the intensity of use of water or access thereto, or construction and continuous reconstruction, demolition, whatever. And they were focusing on the use of the property. And the theory was, say you have a condo or single family home with 2 bedrooms in it. Well, the short-term rental might rent what before was to a family of 2 or 4 people. All of a sudden, it's a party house, or you got 8 people in there. And that's a change in the intensity of the use of the water that would be adjacent to the house. And that would enact the Coastal Act about that. So that was the argument that was being made by this alliance. And it didn't really get very far. The court has some interesting common sense analysis here. One was about if you extrapolate the theory, if someone gave birth to more children than originally was in the house, does that mean you're now in violation of the Coastal Act? So that didn't work. If you had a house guest for a week, is that changing the use? I mean, they just figured it could become absurd. And they talk about what if you have a nanny that moves into the home, the house guest, or the owner of the house had a baby. It's just not going to work. There is a quote in the case that I know that Neil liked. It said, the word residence in the act does not imply a minimum length of occupancy. Okay, so they also open it up that the occupancy in that section of the statute means someone could reside there for a night or a week or a lifetime, and that's not going to change the use and the intensity here. So it was a creative argument that these guys try to make. The courts, both the trial court and the appellate court, shut it down. I think people that want to challenge short-term tenancy issues have to do it on a very local level and not effectively statewide, and on something that's tied already to a local ordinance. That'd probably be the only way to do it. What do you
So
think?
when I was looking through this case, Michael, I was thinking, I'm not sure that the end goal was necessarily to prohibit short-term rentals by calling them developments, because even by Alliance's own statements, right, they acknowledge that using a property as a short-term rental will increase the use of, or access to, the coast, the water. And one of the goals of the Coastal Act is to increase access to the water. So it seemed to me that maybe their end goal here was just to put up barriers to the use of properties as short-term rentals, that they would have to go through and seek coastal commission approval, or if there was already an agreement with the locality approval. But the locality, given what's happened in previous cases concerning short-term rentals, would almost always approve a short-term rental because it's increasing access to the water. So even if it were considered a development, that development would undoubtedly, or in my view, undoubtedly always be approved, but it was creating, to me, the alliance was trying to create hurdles, fearing that maybe a lot of people would not bother going through that hurdle. And because they would not bother going through that hurdle, there might be a decrease in the number of short-term rentals. Here, the short-term rentals, we're focused on Airbnb, but they could be other short-term rentals as well. So I was thinking that might have been sort of like a hidden goal. Let's make it more difficult, even though we think, even if our argument was bought 100%, that one had to go through the coastal commission of the local jurisdiction, they would likely approve it anyway, but maybe we could limit the number of rentals because a number of people will just be scared off. Oh, this is too much of a hassle. We don't want to bother going through those steps in order to rent our property out on a short-term basis. So that was something that I sort of took away from this case.
Like anybody else, you can look at the same phrase and interpret it to the left, to the right, as increasing access or development, having more people there, is whatever. But yeah, I see what you're saying.
I mean, the other thing that I thought, maybe is worth thinking about if anybody reads the case, which is the court was focusing on residence, and you can have a residence for a night, and it really did not take into consideration that there's short-term rentals that are basically full-blown businesses, and there's never anybody who's living there on a regular basis. And if a property is a business use in an otherwise residential neighborhood, does that change anything? And maybe it doesn't, because if it was a long-term rental, that would be a business use as well to the owner of the property that was renting out the property on a long-term basis. So it may not change anything, but the court said, we don't even need to address, or the court did not even bother addressing that other potential issue. Michael, I see our guest is here. Our guest has signed in. I guess our guest, Judge Kalin, you were given my login, so it's showing my name beneath your face. So first of all, I want to say welcome, Judge Kalin. If you know how to change the name, that's great. If you don't, the guy in the gray suit and the very attractive sort of greenish tie, that is our guest today. And I'm gonna there we go. That is Judge Kalin. Thank you very much.
Computer literate too.
And I'm gonna go change our slide so we go to your slide, and we'll let Michael start talking.
All right. Well, good afternoon, Judge Kalin.
Good afternoon.
So did you finish your mediation, or are you on a small break?
We are finished for now, and I've got a few minutes, so I'm happy to be here.
All right, great. So I was very excited to be able to interview you. And I was thinking about this earlier today. I've lost trials before you, but I can't remember ever winning one, but I've always had a lot of fun.
I was hoping you were going to say you've won and lost. I feel bad.
I can't. I think as far as trials, I can think of losing. I can't. And the ones I lost, I should have lost. Like, come on. But
well, I feel a little better.
But it's all right. So I'm glad you could join us. And now you've changed your vocation a little bit from the Santa Monica courthouse to being a private mediator and arbitrator. So I want to talk about that a little bit. How have you found, have you had any arbitrations yet, or are you just doing mediations?
I haven't had any actual hearings. I've got a number of arbitrations that are scheduled for hearing. So
Okay.
nothing has gone to hearing yet. I've spent most of my days doing mediations. It's about
And
90%
how,
of what I do.
and how do you find mediation being different than being a bench officer?
Well, I did a ton of MSCs. My staff had Thursdays open for me for MSCs. I always did that on purpose. I think mediations in the private sector are very different than when doing an MSC on the bench. We can come back to that. But I think the biggest change is I was very private on the bench. I didn't go to bar events. I intentionally kept a little bit more distance from lawyers than I otherwise would have, because I never wanted a decision I made on the bench to be impacted by a relationship. So I was more distant than many judicial officers, especially in civil, and maybe more than I should have, but I'm always happy that I called the balls and strikes as I saw them. It's great now to actually get to meet lawyers and to find out, a little bit more about them. That's the nicest part of my new job, is I get to spend time. You spend 4 hours or 8 hours with me or more. We get to talk about real things, not just the cases. So I love that. That's probably the best part of the new gig.
Yeah,
So,
that's great. So I have a question for you.
okay.
Kind of ties into what you just kind of mentioned. As a bench officer, what usually prevailed, justice or the law?
Well, I had to follow the law for a number of reasons. I took an oath to do it, number one. Number two, if I didn't, I would get reversed, and that would cost everyone more money. I think the more interesting aspect to your question is what happens when the law is gray, or you're in a muddy area where there really isn't any law. Then obviously I would use justice as my, kind of my what's the word I'm looking for? My compass here. What's the fair outcome? There really isn't any law here. Let's at least do the right thing, so that if I get reversed doing the right thing.
How about as a mediator, what prevails, justice or the law?
It's a great question, because obviously I've tried a lot of cases. So I always look at my mediations with the perspective, or the view of what is the best alternative to a negotiated agreement. It's something Roger Fisher and Paul Urey and Getting to Yes talk about, the BOTNA. But since I've lived in the civil litigation world and I've tried a ton of cases, I have a good feel for what is the best alternative. Then you get to the real world, where, there's 100 factors that play in. Hopefully justice and what's a fair outcome is at the top of the list, but sometimes you can't get the fairest outcome because maybe one side doesn't have the resources that would be needed to get that fair outcome. There could be 100 reasons. And so then my goal is to get get an outcome that both sides think is fair and can live with, because ultimately it's their decisions, not mine.
A fair and just resolution.
Something that they can live with. Remember, what's fair and just to you may not be fair and just to the other side or even to me. But my goal is to try and resolve your matter, because oftentimes going to litigation is the least likely to result in that, meaning it can be really costly, as you know, and it can, judges shouldn't split the baby. And I don't know of those who do. I certainly didn't. In mediation, you can split the baby. You can do all sorts of things that you can creatively get to resolve a case that you can't do in a courtroom.
And that's why you want to mediate, is because you don't want half a baby.
Correct. Well, nobody wants half a baby. It's not, you want the right outcome, and you want an outcome that's rational and that you can live with. And that's what hopefully I can help people get to, is what's rational, what can you live with, and what makes sense.
Mike, if you don't mind me interrupting just for a minute, I'm sure not all of our listeners know Judge Kalin. So if you could just give us like a brief background. how long were you on the bench? How long have you now been in private practice doing ADR?
So I was on the bench. I was appointed in 2002, December 02. I was on the bench for 20 years and 2 months. And one of the, I guess, the coolest aspects to my tenure on the bench is my first assignment was civil in Santa Monica. And if you send messages and ask me how I got that, I have no clue. I literally
Pretty
have,
lucky.
yeah, to say I was lucky is an understatement. To get your first assignment in the West District in Santa Monica in civil, I had Judge Haber as my supervising judge who looked out for me. I was doing everything. The first day in my court, in the courthouse, Judge Haber took me into his chambers and basically apologized to me, saying, "You're going to do everything in this building, and I apologize. It's a terrible assignment." May he rest in peace. I know he's looking down and listening right now. It was it was awesome, a great assignment, because I did everything from small claims to small claims appeals to unlawful detainers to, I didn't do a lot of traffic, even though I think we had in the building, but early on, I did a ton of general jurisdiction court trials because the courthouse at that point was filled with judges who had a ton of experience, 18, 16, 20 years on the bench. And when they found out I was there doing overflow, judges don't always love doing statements of decision. They take a lot of work. And hey, Kalin's here. We'll send it over to him. So I was in the best assignment in the world to get a ton of experience early on, including, I think I did my first MSC in a general jurisdiction case within 6 months of being on the bench. And back then in Santa Monica, we all did MSCs for each other. So MSC being a mandatory settlement conference, the judge version of a mediation. So I got just a ton of experience early on. What else? Oh, how long have I been in the private sector? I retired March 1 or March 2 of this year. So I've been out for the last, 7 months now? However many months, 6 months, 8 months, whatever it is. And initially, I of course missed the bench, as anyone would who had such a great experience as I did, and now I don't look backwards. I'm thrilled with my new job and thrilled with meeting people and getting their cases settled. It's just wonderful.
Did you take any time off, or did you just jump right from having a trial one day to because it says you're with ADR Services? Is that an exclusive arrangement or not? So what
Yeah,
does that?
if you want me, you call ADR. So you call Chelsea or Team Chelsea at ADR, and they will book me whenever you want, whenever I have the time. A really good question. Did I take any time off? At the beginning of each year, a judge gets a certain number of vacation days based on your tenure on the bench. And because I had been on the bench for 20 years, I had the maximum, which is a ton of days off. I took all of those days off, but, and this is the big but, I tried cases throughout that time. I didn't take the time off officially. I was trying cases. So in response to your question, did I just try a case and leave? I tried one. I either tried 2 or 3 and then had to issue a bunch of rulings on some really complicated matters that I had pending that I didn't want to leave for my colleague who was taking over. So I think I issued my last ruling on March 1st and retired that evening and started here the next day. So no, I didn't take any time off. I thought that I would get a couple weeks or months to get back in shape, work out, exercise, do all sorts of things, write, because I write as a hobby. And I got lucky. I got busy quickly and that didn't happen. So my planning didn't work out, but I loved every minute of trying cases on the bench and I loved it to the last minute. So I have no regrets at all. It was awesome. It was a great way to go out. Did we lose you, Neil?
No.
Can you hear me? My video froze, so I shut off my video.
I can hear you, and I'm looking at
Okay.
your name. It's like my name, only without an R.
Yes, yeah, that's correct. So I'm glad you can still hear me. I shut off my video to stop my program from freezing. So
No.
Thank you, Michael. What else do you want to ask Judge Kalin?
Well, when you're doing these MSCs in court, so I'm a civil litigator. I'm doing tons of mediations. all the time. And I've learned some techniques, but I'm thinking as a judge doing an MSC, you want it completed within 3 hours. Okay, it has to be really quick. So you had to have different techniques then compared to in the private sector. So have you been able to find any techniques, or do you have any recommendations, how we can use a private mediator to settle a case in 3 or 4 hours as opposed to the 10 hours that it seems to take?
Well, there's a lot of things to unravel there. First and foremost, I was never good about 3 hours as a judge. I think anyone who's done an MSC in front of me knows that I would stay till 10 or 11 if I needed to. I do agree with you that there are a lot of cases that can be settled in 3 or 4 hours. The parties have to be willing to accept that and understand that, and everyone has to move quicker, which I'm fine with. I've settled a ton of cases in 4 hours or less. There are some cases that can't be settled in 8 hours. There are some cases that can't be settled in 4, but a lot of those cases I've settled months down the road, as you know, and hopefully some lawyers listening. I just settled a case that's been pending with me for about 3.5, 4 months. And so I'm thrilled that it finally got done. Sometimes it just takes time, but I think the difference between shorter and longer mediations is the dispute that's at issue. There are some people that need to tell me the whole story, and they need me to listen. And I need to listen to help them get to a place where they can settle. There are other disputes, maybe a business dispute, where I can walk in and someone's going to say, hey, we've evaluated the case, it's worth X. And the other side says it's worth Y. Let's start rolling up our sleeves and get it done. So I think it really depends on the case and the parties and the lawyers. But yeah, cases can get done in 4 hours. I do that all the time.
One of the things that I do sometimes is I use a mediator as a sounding board, or maybe like an expert lawyer witness, because there are some complicated legal issues that come up, and I inquire as to the mediator. I say, this is our position, they have this position, this seems to be where we're stuck. And they sometimes they give opinions, sometimes they want to not, and just say, let's focus on the money. How do you handle, will you handle the mediation, giving someone an opinion about a legal issue?
I think every mediation I do, people ask me legal issues. Lawyers ask me, clients ask me. As you know, there isn't typically a black and white answer to most legal issues, because all of us practiced law at one point, and we've all had wonderful judges who made rulings exactly by the book. And every now and then we get burned by a ruling that, we've been burned by something that made no sense to us. And so we live in a world that has an objective component to it, but there's also the subjective element, meaning the judge and or the judge's research attorney may not always rule the way you think is perfect or right. So I don't ever tell people you're going to win or lose, because when judges would tell me that and I won the trial after they told me I'd lose it, I'd like to keep those transcripts of the verdict. But I can say you have a better argument, or I can say, yeah, you're much more likely to win than the other side. Or I'll analogize to that poker on TV, where they have the river and they give the odds, and every time they turn over another card, the odds change. It's kind of the way a trial is, and it's kind of the way mediation is. I'm happy to go over legal issues. It's something that I love doing. And I think it's even on my website with ADR that I talk about that helping you resolve a case is in large part based on what your best alternative is, and that's a trial. So yeah, I'm always willing to talk law. I enjoy it.
Yeah. Also, the parties have to understand every aspect of what might pop up, that there might be legal issues that are clear and others that are just not clear. And do you want to gamble and end up with a quarter of the baby, none of the baby, half, who knows?
100%. And it's something that happens in almost every mediation that I do. It's why you're here. You've filed a case in most of the mediations. Others are pre-mediation or pre-filing mediations, either required by contract, or maybe sometimes they just want to get rid of it before filing a case. They actually want the privacy of not having filed a case and the kind of secrecy, or shouldn't say secrecy, but the privacy. So, but most cases are in litigation or heading there. And so, yeah, I think it's reasonable to talk about the law. I do it all the time.
Well,
And I enjoy it. It's what makes it so fun.
that's what's important.
Yeah, no, I love doing that.
I mean,
And
I
love
remember.
trials that way. Remember, it's not just the black and white law. You could have the law on your side, but what about the impact your case is going to have on the jury? Because there's two sides to this. You have to have, I always say this, you have to have a legal hook and you have to have an emotional hook. You could have the best legal case in the world, but the jury could hate your client or hate your case, and then what? So yeah, we talk about everything. I love trial strategy, and I love the legal aspect, the law too.
Yeah, I remember this is one of the things I always enjoyed before you was we could argue, dissect the cases, you give us your feedback. You're excellent at that. I always saw you in your, whenever I passed your department, you're always there. You really should take a vacation every so often.
Well, now I'm here every day. You can walk by the ADR offices. I seem to be here 5 days a week, which is wonderful too.
I could walk over. And I did have a case with you that you helped settle, and you didn't give up. And I think that one of the techniques you had, that we waited several weeks and then you got involved, and it worked out very nicely, even though my client paid a lot more money than I thought he should have.
It's where that when you ask me about justice, as I said, sometimes to get a deal done, both sides are not happy with me, but I think they're happier with me than they would be had they gone to trial.
Yeah, well, there's theoretical and practical, and practical is what I think we need to focus on.
Agree.
So, well, thank you for joining us.
My
you're welcome
pleasure.
to stay and tune in, or have lunch and take a break, whatever you want to do.
I will probably, because I found the last discussion so interesting, I'm probably going to turn off my camera and listen a little bit more, and and I'll sign off at some point. But thank you for inviting me. It's been an absolute pleasure, and can't wait to work with you and everybody else some more.
Well, thank you. And you can turn off your camera, but if you want to chime in, feel free.
I'll be happy, but I'm
absolutely. Thank you so much. And we don't consider it a matter of behaving. We love to get additional input. Michael and I don't always agree. And anytime we can get another perspective, it's always welcome. So whether you want to be quiet or whether you want to chime in every once in a while, you're welcome in either case. Thank you so much for joining us.
Thank you for having me. I'm going to turn off my video and I'm going to learn about Iton versus County of LA. I can't wait to hear this presentation. So take care, everyone. Have a great day.
Thank you.
Thank you. So Michael, I think you said you wanted to start talking about Iton. But before you do, I will make an announcement. Assuming all goes as planned, the organization that brought this case, a representative, because I believe it was PLF, Pacific Legal Foundation, and we're going to have a representative joining us for our November What's Up and talking a little bit about Iton, and we'll get to hear it from the horse's mouth. Now you just get to hear it, I don't know, from some other part of the horse as Michael and I talk. So go ahead, Michael.
Okay, so this Iton case is one that's been popping up recently. It's a COVID extraction. And this one focused on the contracts clause and the restrictions that were put on evictions in 2020. This case, I found all of these things fascinating, especially the historical analysis. And a lot of people hear about contracts clause, this is federal law, essentially constitutional law. And it's good to know the history of it. So I do recommend someone reading this. And the judicial officer that wrote the opinion is Judge Dean Pregerson. So that's a good experience, interesting bench officer. So anyway, what happened was in the beginning of the spring of 2020, various cities and counties passed ordinances to restrict evictions. And this was both for residential and commercial tenants. The residential were to keep people in their homes. Maybe they couldn't pay rent. Maybe there's some other reason, like they brought in a family member that didn't live with them, and now they have a unauthorized occupant, something going on. And so they passed some laws to prevent evictions with some very tight exceptions, okay? In this Iton case, the LA County passed some laws that were temporary restrictions on evictions for tenants impacted by COVID-19. And one of the aspects of the county law is that a tenant could self-certify regarding their inability to pay. They didn't have to prove that to the landlord. And that was actually fairly common even with the cities. One other digression I'll make is the county law trumps the city law. So if LA City or Santa Monica had a less restrictive law or a weaker law, the LA County law would trump it. Anyway, the plaintiff, Iton, owned a commercial property that was being subleased to an auto repair business. The auto repair business in April of 2020 stopped paying rent. And he didn't pay the rent again. He also had a lease that expired on its own terms after August 2020. So his fixed term lease was going to expire soon. And in April of 2020 and May 2020, nobody knew what was going on as far as COVID, how long it's going to last, what's involved. I think people have short-term memories about things, but it was a difficult time for a lot of people. Anyway, the tenant gave verbal notice that his ability to pay rent was impacted due to COVID. And not written, but verbal notice. He did that. So everything was pretty much okay. But towards the end of the summer, it seems, the tenant and the landlord negotiated a new lease. So the landlord recognized he didn't want a vacancy, and the tenant assumed that, I presume, he thought he could continue to do business either at that point in time he was doing business or in the near future. So they negotiated a new lease. But guess what? That nasty tenant, he didn't pay any of the rent. Not only did he stop paying the rent, but he negotiated a new lease where he promised to pay the rent, but he didn't pay the rent. What could the landlord do at that point? So the landlord thought, can we evict him? Well, if the landlord had called me, I'd probably say, I don't think you can evict him. I think he has a defense. If he says he has the inability to pay, and as far as the proof of that, I don't know what's going to happen. But in the summer 2020, everything was pretty frozen. I tried to do an eviction and we got it, but it was a very unique case involving safety. But this is just rent, just money. It's not a health and safety issue. So the landlord's attorney came up with a fairly novel idea. He thought he would sue for declaratory relief under the contract clause of the United States Constitution. And declaratory relief is not going to end up evicting the person, but I could see they thought that's going to start a very serious conversation that maybe we should work something out. Apparently it didn't. But the court went through an analysis of the contract clause and also looked at the ordinance. And the first impression was, this ordinance, it doesn't say you're prohibited from doing an eviction. It just says the tenant has an affirmative defense to the eviction. So maybe that's not an impairment of the contract clause. Okay. Did you see that part, Neil?
Yep, I did.
Okay. So then they're still kind of going on like, well, what can we do? Well, the district court said, I don't think you have declaratory relief. We're saying that you lack standing. It granted leave to amend, but at first the case got dismissed. I think there are other reasons for under the declaratory relief statute. This could have been dismissed, but they went under the standing was the focus there, I think. Then they amended the complaint, and the courts did their analysis, and they're looking at state law to determine whether or not there's a cause of action that was impaired, and he had a cause of action. So even when this case went to appeal, the court came up with the same basic conclusion. that you may not be able to win the underlying case, but they kind of reverse something. They go, but think about it. You must have standing to assert some sort of interference here. So the court thought, yeah, I guess you could have standing. We can reverse it, even if you're going to lose. But I think you have a basic cause of action, especially under federal law and federal pleading requirements. And so they reinstituted that case. I'm not sure what happened at the very end. The court made some comments about the tenant's notice, about, verbal notice. Is that okay? Do you have to give any notice? The tenant had his excuses about, well, I guess I don't need to give a notice every month, but does the statute, the county statute require notice every month? Yeah, it does. So we have, those issues that the court still had to determine, but they reversed it and remanded it that there may not be a likelihood of winning, but as far as standing, Mr. Eitan could, plead his case.
And what struck me about this case, aside from the distinction the court made that you just talked about whether you actually, whether you can win versus whether you have standing to raise your claim. But I think it's going to be a big issue if this case goes forward on the merits, to see what a court would say. And again, this is a federal, it's in federal jurisdiction. What is the court going to say about the contracts clause and its application, if they want to reach that issue, its application? Because early on, when we saw COVID cases, right, incredible deference to government entities, incredible deference, to the executive branch. Now, that we're 3 years behind, the beginning of 2020, and who knows how many more years it's going to be before they have their day in court. Maybe memories have faded. Maybe the urgency is not there so much. So maybe the deference will not be there as much. I have absolutely no idea. But the fact that there's the possibility of getting a contract clause, a case addressing the application of the contract clause to these moratoriums, and the issue is not so much the moratoriums anymore, right? The issue would be what could potentially come next for whatever other emergency comes in the future. And so to me, that's probably the most exciting part about this case, is if a future court will actually reach the contract clause and make a decision on that basis.
Well, I don't think they will, because the big picture, and I know judges like to look at the big picture, is the money that was not paid in 2020 or 2021 has to be paid now. Okay, so that money payment moratorium is over. The money was never waived, it was just deferred. So how is that an interference with anyone's contract, right?
And that's a possibility. And I guess the issue would be, so essentially you're making an argument that if the money needs to be paid, whether it gets paid or not, that the entire issue could be deemed moot, right, at that point, because the money is now due, or will soon be due, whether it gets paid or not. And I guess the issue would be, will the court say that the substantive issue is important enough that we would hear the case on that basis anyway?
But the goal of the contract is to get paid money. So the payment of money obligation never disappeared.
And it's really just a deferral, right?
Yeah. It's
a deferral of 4 years, maybe up to 4 years time to getting the money. I don't know. Like I say, but the interesting part is the substance. I'm not a litigator like you, Michael, right? So I'm more focused on those big issues that will have an impact going forward. And I know you pay attention to a lot more of those details that affect litigants in their day-to-day basis.
Yeah, well, apparently in the 1800s, the contract clause is a big deal. So everything is circular in life. It's coming back.
That's right. So we'll see what happens. Well, let's move on and see what else we got. We already had our interview with Judge Kalin, so we're going to move on to Carr versus City of Newport Beach. One of my favorite types of cases, because I love cases that have a dissent, right? Because that means this is not just an easy case. Somebody had to think about this. So we'll quickly look at the facts here. Carr walked onto this 20-inch wide seawall. It's called a, reading this case, dove headfirst into Newport Bay, and terrible tragedy, right? Hit his head in the bottom, left a quadriplegic. He winds up suing the city for a dangerous condition of public property, failure to warn. You see right there, the city moved for summary judgment based on immunity in the government code. And down at the bottom of your screen, you can see the relevant portion of the government code, which actually we're going to see is very important in just a moment. Okay, so the court grants the city's motion for summary judgment and says, well, you may have been injured, but there's absolute immunity here when we look at 831.7 A and B. Carr appealed. The court says, well, if we look at this situation, if we look at 831.7, there's no liability of public entity or the employee if a person participates in a hazardous activity. What is a hazardous activity? Now we look at B2. Any form of diving into water from something other than a diving board or diving platform. And then there's an or it says, at any place or from any structure where diving is prohibited and reasonable warning thereof has been given. And so to me, two questions that come into play just looking at the statute is, well, okay, what about that phrase, and reasonable warning thereof has been given? Does that only apply to the language after the or does it apply to the first part where somebody is diving from something other than a diving board or a diving platform, right? So that's going to be a potential question that's going to be raised. The majority looked at this, and it seems to me the majority is saying, well, that giving reasonable warning really only applies to the second part of B2. Any place or from any structure where diving is prohibited, where both diving is prohibited and reasonable warning thereof has been given. Now, if you look at that language, you could say, okay, so here Carr dove off of this seawall, and there were the opinion, and I've rarely seen this in two dozen years, where the opinion actually has pictures, right?
But what is about a groin? You need a picture of a groin.
Picture of a groin, showing what it was, showing a sign saying that swimming is allowed in this area that's right near this. So I was looking at it, I was thinking, well, okay, so in the beginning part of 2, any form of diving into water from other than a diving board or a diving platform. So is this groin, is it a diving platform? Is it something that somebody in the public might think, well, this is a platform. Of course, this is used for diving. This is just, it's kind of juts out, into the bay. And of course, you could use it for jumping. You could use it for diving. I mean, that's not the purpose of it, right? I think the purpose of it was to prevent erosion, but might a member of the public think that this is a diving platform? Anyway, the majority made their decision. They thought that they had a duty to find for no liability. They had a duty under the statute to find that there was immunity. The dissent disagreed, right? The dissent is interpreting the statute a little bit differently. But you could tell from reading this opinion that both the majority and the dissent feel terrible, for Carr. I mean, Carr obviously suffered a catastrophic injury. And they both sides sense that there's something wrong here. And something needs to be done to address that wrong. And both sides, majority and dissent, saying, you know what, the legislature really needs to step in and clean up 831.7, or the California Supreme Court needs to come in and give an interpretation to clean it up, because you could just tell they both did not like the result of Carr not having a valid cause of action against the city. Michael?
Yeah, I just posted in the chat a link to a groin. So
Okay.
anyway, yeah, this is not the normal webinar, right?
Right.
So I agree. But they talked about-
unfortunately, Michael, I guess is talking about groin was too much for Judge Kalin, and I see he just left us. Okay.
you missed out. Anyway, okay, so this is really about a sign. This isn't really about the city or the county, department in charge of that area should have posted some signs that say "Don't dive." Isn't that kind of like what they're kind of the end result?
Well, I think certainly that's what the dissent was saying, was that there should have been that warning, and without that warning, then the immunity did not apply. But whether 831.7 applied or not, one would think that the city would sort of be on notice, and just as a security measure, as a precautionary measure, as a measure for interest in the citizens who use the bay, might want to post a sign like that as well.
Yeah, I mean, if it's, to me, it might be appear to be dangerous to try to dive around there, and you have this gross negligence exception. But I don't know. It's I see a lot of no diving signs along the beach when I go walking. I've seen that, so I don't know why they didn't have that.
Yeah, I can't explain that either. Obviously, the dissent felt that was a decisive factor, and the majority felt, no, we're bound by the language of 831.7 that was enacted by the legislature, and we think if it needs to be fixed, it's up to the legislature to do that. So again, at least an interesting decision. Any decision with a dissent usually means that it's a close call, right? And that reasonable parties can come to different conclusions on the same set of
And
facts.
passing the buck. And going back, I like that when the courts say, legislature, clarify. Who do you want to protect and why?
Right. And what did Judge Kalin say? He said his duty was to follow the law, right? And then if the law was unclear, then he could start looking at other factors. You mentioned, justice is one of those factors. But the majority said, our duty is to follow the law, but not to write the law. And if the law needs to be rewritten, that's the responsibility of representative government, not the judiciary.
And as you said, I really suggest people look at this opinion. It's not just a couple photos, but they did this cute chart where they checked off the box, yes or no. Was the diving board a platform? Yes or no. Was there a prohibition? Yeah. It's not very clear with their thought process.
Yep. They both put a lot of thought into this case. All right, well, Alliance versus San Diego. You know what, Michael? We're getting near the end. I think maybe we'll save Alliance versus City of San Diego, because you can see there's a lot of issues in the Alliance case. So maybe we'll save this for an upcoming month, and we'll just go to our announcements. We'll let our audience make sure we get out of here in time. So what's coming up? Real property webinars, both in October, parts 1 and 2 of distressed real estates, workouts in litigation. So you're looking for some good hours. You think you know, the way the real estate market is going, especially the commercial real estate market, we might be looking at some more distressed real estate going forward. You know, look up, go onto the CLA website. And Nicole, if you're listening, maybe you could post in the chat the CLA website. And then you can always click on the real property section tab to find out more about this. We're always looking for great ideas for webinars. Our webinar contact is Marty Triano. Always looking for great ideas for short that would appear in our monthly newsletter. And the contact there is Kyle Yagi. And for these short articles, excuse me, they can be anything. They could be a case summary if you want. They could be discussion of a recent case that you had. Maybe you would want to keep the parties private. You don't have to reveal the identity of the parties. Or it could be an issue that maybe you've recently researched that you think would be of interest to other real property practitioners. If you want to do a long article, that's our Real Property Law Journal or the Real Property Journal. And Brian Payne is the contact there. Coming up, well, you know, guess what? Starting tomorrow is the CLA annual meeting. And I noticed something that came into my inbox 2 days ago. So if you're going to find yourself in San Diego, you want to go to the CLA annual meeting, you can still do that. There's no hotel rooms anywhere near there, but if you're in the area, great. Or if you already have a hotel room, good luck. And then, you know, early warning, next year, our real property retreat, now combined with the annual Women in Leasing Law Symposium. Next year, instead of being up north, we're going to be in Southern California in beautiful Rancho Mirage in the beginning of March. So just think about that. You want to join one of our committees? Great. Look what we have there. Litigation. Actually, we don't have brokers anymore. I need to remove that. But financing, residential leasing, commercial leasing, land use, construction, homeowner associations. A new committee just started last year for real property section, ADR. And then we have a DEI committee. And I want to welcome Chip. They're going to start actually at the end of this weekend is when the new CLA year starts. The new chair is going to be Franz Farrow. The secretary is going to be Mark Gutierrez. And the treasurer is going to be Cosmo. From them next year on What's Up With Us. Michael, I don't have anything else to say. Do you want to close us out?
Well, I've been doing this with you for about the past year. It's a lot of fun. I hope that our participants have enjoyed how we approach these cases and learned something that can be useful in their practice. But thank you.
And if you enjoyed it, I say, tell some of your colleagues and have them, give us a try. It's free. It's an hour. You can sit and eat your lunch. You can listen to Michael and I pontificate, right?
Babble.
And hear from somebody more interesting than us as well.
And if you want to be interviewed, let us know. If you're interesting, we're there. So please let us know.
Right. You can contact either myself or contact Michael. The next What's Up With Us is scheduled for next month. Our schedule is the third Wednesday of the month at 1:00. Thank you, everybody, for joining us today. And we got one case already to talk about next month. Can't wait.
All right. Thank you.